Can you hear me, Peter?
Sorry?
I can hear you, Carl.
I can hear you.
Good, thank you.
You're welcome.
Good afternoon. During the declared emergency in the City of Toronto, Committee of Adjustment virtual public hearings are being conducted via WebEx, an online digital platform, and will be live streamed on the Toronto City Planning YouTube channel. These measures are necessary to comply with physical distancing requirements and a provincial order that limits attendance at public gatherings. My name is Nancy Oman and I will be chairing this hearing. Panel members participating via WebEx and who can be seen and heard are Larry Clay, Carl Nipfel, and Peter Reed. City staff will be assisting us throughout the meeting, including moderating the WebEx platform. Agents, applicants, and other interested parties participating in this virtual hearing registered in advance and will be connecting through WebEx using a compatible electronic device. Their participation will be through audio only. We acknowledge that the land we are meeting on is the traditional territory of many nations, including the Mississaugas of the Credit, the Anishinaabe, the Chippewa, the Haudenosaunee, and the Wendat peoples, and it is now home to many diverse First Nations, Inuit, and Métis peoples. We also acknowledge that Toronto is covered by Treaty 13 with the Mississaugas of the Credit. In accordance with Sections 45 and 53 of the Planning Act 1990 as amended, this meeting of the Committee of Adjustment for the City of Toronto is called to order. The Committee of Adjustment considers applications for variances from the provisions of the zoning bylaw that apply to the property, permission to extend or alter lawful non-conforming uses, and consent to sever property to create new lots. Anyone who wants to receive a copy of the committee's decision for an application must submit a written request by email to the general email address for the Committee of Adjustment, Toronto and East York District Office. Please include your name, address, and an email address. All Committee of Adjustment and TLAB notifications and appeal updates will be sent by email only. If you do not agree with the decision of the committee, decisions may be appealed to the Toronto Local Appeal Body, known as TLAB, or in some limited circumstances to the Ontario Land Tribunal, known as OLT. Appeal instructions will be set out at the bottom of the committee's decision. Participants who have registered in advance will be connected to this virtual hearing and will be muted upon entry. When your item is called, each participant will be unmuted by the moderator, one person at a time. I will call each item in the order listed on the agenda. Where an application is uncontested, the agent or applicant may proceed with their presentation if desired, and when the committee does not require a presentation, applicants are to advise the chair should they wish to speak to the committee. The committee may ask questions and/or take the matter into committee for a decision. Each speaker, including the applicant or agent, will be given a maximum of 5 minutes to address the committee, and I'll comment when you're reaching the 5-minute mark. When addressing the committee, please speak slowly. Clearly state your name and address, and please confine your remarks to the matters outlined in the application. Where required, the applicant or agent will proceed first with a presentation of the application, and then individuals either in support or opposed to the application will be invited to speak. Committee members may ask questions of each speaker after they have completed their presentation. When all speakers are finished, the applicant or agent will be unmuted and will have an opportunity to rebut only those issues that were raised by the speakers. This will mark the end of the discussion, and the application will be taken into committee for a decision. Please note, the committee may not entertain revisions to proposals at the hearing today. The committee may decide to defer the application if substantially revised to ensure that the revised application is accurate and that all those entitled to notice are informed of the changes. Panel members and staff, do any of you have an interest to declare? Seeing none. Madam Deputy Secretary Treasurer, are you aware of any requests to close or withdraw an application this afternoon?
Not today, Madam Chair, but I do have confirmation for the June 30th minutes, so we could confirm those.
Okay, sure. Just give me 1 second. So the June 30th meeting, minutes, sorry.
Yes.
All right, panel members, so it sounds like the minutes for the June 30th meeting have been reviewed by the members, so I need a motion to approve. Mr. Reed?
Motion to approve.
And seconded by Mr. Nipfel. All in favor? Okay, the minutes have been
Thank you.
adopted. You're welcome. Okay, so we're now going to go to the first item this afternoon, which is item number 20, 40 Mitchell Avenue, and I think we can do 21 with it. Is that what you were going to say, Madam Deputy Secretary Treasurer?
Yes.
Great minds think alike. There you go.
Yeah.
Okay.
So I just wanted to mention there's a delegated consent on this as well. I have
Hang on, you're cutting out, so I'm not sure what you said.
Oh, sorry. There's also a delegated consent for this property that I have to consider. I've not made a decision because there are requests for deferral, I think, from planning and heritage, because the heritage designation, I think, is going to be considered in September.
Okay, and I was
So they've
actually,
asked for deferral.
yeah, I was gonna ask you, so, I guess before we start then, is it appropriate to proceed with approving variances if the consent is gonna be deferred and there are some issues with some other departments?
The agent may want to make a presentation or at least address that, but I probably won't be making a decision until until this is dealt with in September.
Okay, and is it just heritage then, or is there another department, just so we know?
Planning is also asking for a deferral, I think, for that reason.
Okay. Okay, well, I guess, let me just read what we have before us and then I'll go to the agent. All right, so what we have before us is basically the same for both item 20 and 21, so 40 and 44 Mitchell. So we have before us a copy of the plan of survey, site plan, floor plans, and elevations. We have a covering letter from the Goldberg Group, who's the agent. We have supporting material in the form of a cultural heritage evaluation report from the Goldberg Group, pre-circulation waive that was submitted by the Goldberg Group, and presentation materials. We have staff reports from engineering and heritage. So I believe forestry is asking for condition number 1 on item 20, and forestry is asking for number 3 on item 21. And I believe both planning and heritage are asking for deferral of the item. And we have correspondence in opposition from 721 Richmond Street West. All right, do I have the agent on the line?
Good morning, or sorry, good afternoon. My name's Michelle Charco, I'm the agent.
Hi, Michelle. So you've heard some of the things that have been said regarding the consent, and I guess you're also aware of the deferrals being requested by Heritage and Planning. And I think...
Yes, I'm aware of the request, but we would still like to proceed today.
Okay. Panel members, do you need a presentation, or maybe we should just address the reports right now and let me get your thoughts on that. Mr.
Chair, I'll start. I don't think I need a presentation. I think the materials from Planning and Heritage are both quite clear, and given that the CRB hearing is in September, I think it's most appropriate to defer.
Okay.
I would agree with Peter. I think you know, it's not a lot of time to wait and see what the CRB rules on, whether it is in fact heritage or not, and I think it would be premature for this committee to consider the application in advance of the ruling.
I agree as well. In addition, as the consent isn't going to be dealt with until September, I don't see any advantage in proceeding today. I support deferral as well.
And I'll add that I believe that if the matter's not deferred, that Heritage was looking for refusal. But I will go back to the agent now. Are you there, Michelle?
Yes, I'm here.
Okay, so I think from what you've heard, the panel is inclined to support deferral.
So the reason that I wanted to present the application today, just for the panel's reference, is because we've had this application in with the city since approximately February, and they have had the opportunity to review everything. Planning staff have provided comments, and the only variance that they don't support is the integral front-facing garage. With respect to the comments that we received from Heritage staff, we did submit a Heritage impact assessment, and yes, it will be reviewed at the Conservation Review Board hearing in September. But ultimately, this is a planning application, not a heritage application, and regardless of what happens with the variances today, we still need to go through the heritage process in September if we are to get a demolition permit. So by delaying and having the deferral, it just means we're going to have to come back again, and there's more delays, because I'm not sure when we're going to get another hearing date following September. It's just going to take more time from everyone else, when the application that's before the committee today is the application that will likely come back following the September hearing, depending on what happens.
Madam Deputy Secretary Treasurer, can you just give a comment on potentially when this would be able to come back? I'm guessing it's going to be dependent on what happens at the hearing too.
Well, yeah, we'd have to wait to see what happens at that hearing, because I guess my question is, if there is a decision to designate and protect the existing buildings, I'm assuming that would change your proposal, right?
Yes and no, it would, but regardless, if the designation doesn't go forward, then at least we've got the minor variant, or the potential minor variance approval or refusal, whatever the status of this application may be, so we can move forward in that manner. If we're not granted the demolition permit, then we kind of know where everything lies, right? Whereas if we are granted it, then we have to come back, and so that's where it's kind of a chicken or the egg situation.
Could I ask a question? The planning department, at least on 40 Mitchell, is opposed to the integral garage, and I'm inclined to agree with them. Are you able to, I'm assuming you're not able to adjust your proposal to remove the integral garage, so am I correct? That you would not be trying to respond to the planning department's opposition to the integral garage?
So I have not had correspondence with the owners with respect to it's not an underground garage, it's just an integral garage. It's that great with respect to how they would like to proceed. But we're within your hands, panel members. You have the power to approve all the variances or refuse all of them, or approve some and refuse others. So, you know, if certain variances are approved or refused and that forces, you know, the design hand to happen, then that's what happens. So I just know that in the past, being before the Committee of Adjustment, I don't like to make changes on the spot.
Okay, but there is some flexibility.
Absolutely.
Thank you.
I also have two speakers. Do you have both of them? Okay, I'm just gonna see where they live, if they're in opposition, and go from there. Hi, Carmela, are you there?
Yes, I live at 711 Richmond Street, which is on a few doors down on the other street behind. I mean, I received notification.
No, that's
about this.
fine. Can you just tell me, are you in opposition to this?
Yes, I'm in opposition.
Okay, and do you support a deferral if that's where the committee goes with this?
Yes, I do.
Okay, I'm just gonna go to the other person, if I can.
Hello?
Hi, Jing Qian.
Hi. Yes, I'm the owner of 46 Mitchell Avenue.
Okay, are you opposed to this application?
Yes.
Okay, if the committee is inclined to defer, do you support deferral?
I'd like to have deferral.
All right.
Madam Chair, there's one more speaker for the second application.
Okay,
Dolores?
hold on, it's on a separate page. Oh yeah, okay, Dolores.
Yes.
Hi Dolores, you're at 27 Mitchell.
That's right.
I guess you've been listening, and you do show in opposition. If the committee is leaning toward deferral, are you in support of deferral?
In support of deferral.
Okay, thank you. Okay, again to you, Michelle. You've heard the committee is leaning toward deferral. You still want us to go ahead with this? Then we'll be basing our decision on all the material before us, including the heritage report.
Yes, I would still like to proceed.
Okay, you have 5 minutes starting now.
So I submitted supplementary materials package, and is it possible to put that package? Yes. So specifically, the area context map is what I wanted to bring to the panel's attention. On the area context map, once it gets on the screen, what we have is 2 existing one-story bungalows which have been flagged for heritage designation. However, the materials that we submitted and through some of the visuals that have been provided, they are in a very dilapidated state. And as it's noted in the heritage impact assessment that we submitted, it states that a lot of the original features have been stripped from these buildings. Some of these original bungalows have been preserved in the area, and you can see them at the top of the page there, and they have had additions. However, these additions have been done in a manner where they're at the back of the property, and you can see them at the top of the screen there at 721 Richmond and 707 Richmond. You can also see, based on this diagram here that we have of the block context, that there has been a lot of redevelopment in this area in a very similar architectural style as to what is being proposed. I would like to bring it to the committee's attention that we don't have any variances with respect to minimum lot frontage, with respect to front yard setback or rear yard setback or landscaping or even height. The variances that we do have, they really are in direct relation to variances that have been approved in this area, and that's also shown on the site planning variance list, which is figure 5. The FSI variance is well within the range of what's been previously approved. The side yard setback variance is very common in this area. This is an area with tight-knit, with some 3-story dwellings already existing with tight side yards. And the building length is also representative already in the area, specifically that one of the dwellings, due to all the extensive additions that have happened to these dwellings, also has a long building length. And with respect to the integral garage, as I've already indicated, we're willing to be flexible on that, but the deficiency is 56 millimeters, which is 1.8 feet. And we can see through the photos that I've just shown that there are some integral garages and other parking solutions as well. But as we all know with the zoning bylaw, we are required to provide parking behind the main front wall of the building, so it does require some flexibility from the bylaw in that manner.
Okay, is that it, or did we lose?
That's it, yes.
Oh, okay, I thought maybe we lost you there for a second. Okay.
No, I was trying to be brief.
Okay, thank you. All right, so let's go to Carmela. You're there?
I guess my main opposition is, hello, do you hear me?
Yeah, I can. I just want to confirm again, you're at 711 Richmond Street. I know you mentioned it before, but,
Yeah.
Okay, go ahead.
My opposition is mostly related to the environmental impact. This is not the first group of houses that have undergone enlargement compared to the base landscaping. And so, although they're not huge variances, they're all declared minor variances for some reason, I think there's a huge environmental toll by allowing all these variances to go through. So my main objection is the environmental one.
Okay, thank you. Panel members, any questions of the speaker? Okay, seeing none. Thanks a lot. Ying Tian, are you there?
Yep. Yes, I am.
Can I just ask you to restate your address for the record?
I'm the owner of 46 Mitchell Avenue.
Okay, you have 5 minutes starting now.
Sure, okay. So I'm the owner of 46 Mitchell Avenue, which is immediately west of number 44. I'm here to object this application since I believe the setback, building depths, and the vehicle entrance fail to create an acceptable impact on my property and community. Mitchell Avenue is a road with permit-only overnight parking, and their proposed frontage is only 7.06 meter versus 7.6 as required. It is way narrow for a vehicle entrance. If violation got approved, the density of vehicle on the street will be affected. At least 2 public parking will be taken away. Yes, they will create 2 additional driveways, but this is based on sacrificing public's interest and right. Like 18 and 22 Mitchell Avenue, they are newly developed with their private driveways, which are very similar to this application. But based on my research, they both have 7.62 meter frontage, completely complied with bylaw. So I put the lot information in my, I have sent the material for the presentation. I'm not sure the secretary can bring it out. Yeah. Okay, because my speaking is around like 5 minutes. If can this kind of give me more time to do this? Oh yeah, okay. Yeah, the first picture is showing the lot information for 18 and 22 Mitchell Avenue. They have their legit frontage. So I disagree this vehicle entrance variance. It's sacrificing public interest for their private benefit. Second, the maximum permitted FSI is 1 time, and their application is 1.38 time, an extremely outlier. So this will direct future capacity change of the street. Other developer can just follow this unacceptable variance if it gets passed. So I disagree with the increased FSI. And that's the most important, their setback. So they want to decrease the setback from 0.45 meter to 0.15 meter. This 30 centimeter setback variance is a 67% in decrease compared to the bylaw. So it's causing an adverse and significant impact on natural light for my first and second floor. On their cover letter, the page 4 of their cover letter, they stated both of their neighboring dwellings are situated with 0 setback. This is misleading and wrong because only the very front part of 46 Mitchell Avenue is attached with 44. So the picture 4 is the back view of my house, which proves we are not 0 setback. 4 windows on the east side are brightening my major living area. In picture 3, the next, I have kind of attached the interior view of my windows for your reference. So this is a critical natural light source for us. Moreover, the setback variance will cause less sunlight exposed. Surrounding houses might just get more moisture and more easily get damaged. Privacy, integrity, and snow accumulation on the roof is also going to get a severe impact from it. I checked 18 and 22 Mitchell Avenue. Their neighbors don't have any window or lighting source on site. So that development is not affecting others' life, but this development will. So I attached the picture 4 as the proof. The next page, please. Yeah. So that's the picture for that development. So therefore, I completely disagree the setback variance on both sides because this is sacrificing others' privacy and the lighting sources. Saying the building depth variance, that their massive 3-story building's shadow will for sure negatively affect their neighbor with a longer depth. So I'm object to it. So my house is a 123-year-old Victorian beauty. Its ground level is already the lowest one between 48 and 44 Mitchell. So the water distribution is toward to us, and this development will make this situation even worse. The old foundation is not solid as newly built. More water flow means shortened life, and the beam of 46 is already slightly leaned to one side. Any huge vibration, loosen underground soil, and changing weight will make it worse. So this development is risking surrounding old houses and the residents' safety. As the new generation of Toronto, I do want to preserve these beautiful old properties, and my house deserves a quiet underground and fair water distribution to stabilize her and make her life longer. At the very last, So as the owner, I have never got touched by this developer about this plan. No introduction, no explanation, no shadow study, or just a simple head up about it until I received this surprising hearing notice. So I don't feel the developer care about his neighbor and this community because no respect to us has been expressed. So I hope the committee could consider my points and my evidence to make the right decision. Thank you all for hearing.
Thank you very much. Any questions of the speaker, panel members? Seeing none, thank you. Dolores, are you there?
I start.
Can I have you restate your name and address for the record, please?
Oh, yes, it's Dolores Bukowski, 27 Mitchell Avenue.
Alrighty, you have 5 minutes. We're starting the clock now.
Okay. I think the heritage nomination with all the media and community support it got pretty much covers why these cottages should be protected. The owners of 40 and 44 Mitchell are coming before the Committee of Adjustment with pretty much the same plans they had back in October 2018. And it astonishes me that almost 3 years later, they have not managed to come up with a plan to increase their property value and still keep the heritage integrity of these houses. Other people on Richmond Avenue have managed to do that. Why can't they? That's it.
Okay, thanks a lot. Any questions of the speaker? Seeing none. Okay, thank you. Michelle, are you there?
Yes, I'm here.
Can you please speak to the issues raised by the 3 speakers?
Sure, I can't speak to environmental issues or construction issues. I can speak to some of the planning issues that were raised, however. As I previously stated with respect to the FSI, the proposed dwellings are well within the range of what's been approved. This is a very dense neighborhood. There are plenty of 3-story dwellings, and there are plenty of FSIs that exceed what we're proposing at 1.4. With respect to the side yard issue for 46 Mitchell, what we are proposing along that west side yard is a setback of 0.61. This is a reduction of a foot, and 46 Mitchell does provide for a 0 side yard setback. There is a cutaway at the north, and I believe that's about 0.9, which is what's required in the bylaw. As has been demonstrated in the chart that I've provided there, this is a neighborhood that is a very tight-knit urban context with numerous dwellings that have side yard setbacks that are non-compliant today, regardless of minor variance applications.
Okay, thank you. Panel members, do you have any questions for the agent? No? Okay, let's take it into committee then for a decision.
Madam Chairman, I think that the appellant from 46 Mitchell summed up, I thought, rather well the negative implications of this proposal on her property and perhaps others. She referred to setback issues, she referred to floor space index issues, and most importantly to me, she referred to the issue of parking and how the proposed parking would rob parking accommodation for the public at the expense of providing private accommodation, and appears to be somewhat inconsistent with the area. The planning department is opposed to integral garages on properties this narrow, and the reason is, as the applicant or as the appellant had indicated, it takes too much of the public parking off of the street and removes it from a flexible accommodation for the neighborhood. In addition to that, of course, the planning department and the heritage department have recommended it's premature to review this application. The applicant did not want us to defer it to see whether to be some accommodation. On top of all that, I'm actually quite appalled to find out that the applicant has had no consultation with abutting neighbors on this project. One shouldn't be entertaining a project of this density and of this character without talking to those people most directly affected, which would be the adjacent neighbors. Having said all that, Madam Chairman, given what's been said and what we have before us, I don't see any merit in the application, and I would like to recommend, I'd like to bring forward a motion that both applications be refused.
Okay, anybody else want to weigh in on this?
I'll add my bit. I have significant concerns with it, but not as much as Carl. I think the variances being requested are quite minor from a numbers perspective and also from an impact. I think the houses themselves aren't terribly overstretching what is acceptable, particularly given the context of redevelopment in the area. I do agree that that this should have waited for the heritage decision, but in the context of where we are, my sole issue is the integral garage, and I think both the neighbor and Carl summarized that well, so I won't expound on that. So I would be inclined to approve the application, but deny the integral garage portion.
Mr. Clay, your thoughts?
Well, I find this neighborhood and this street in general to be very eclectic. If you go and look around, you'll see a very broad variety of houses and housing stock and uses, both residential and commercial. So it is, open to change. I would suggest it is an area that's in transition. I'm not, in the absence of the cultural heritage designation, I think that the application is fairly minor. I think, with some tweaking and there are some issues, I think it could potentially be something that would be supportable down the road. But fundamentally, this city has had several instances in recent past where demolition and major changes to buildings that are in the process of being considered for heritage designation, and they are very controversial and rightly really get neighbors and the community upset. So I'm very reluctant to weigh in on this one in any substantive way in prior to the CRB making a ruling on it. I mean, we are making a decision either to, refusing or accepting in the absence of some pretty important relevant information that would be available through the CRB hearing. Whether it's designated or not, I think that's a very important factor to consider on whether we make a decision positively or negatively. So just to make things a little more complicated, I'm actually in support of deferral until we can better understand the context within which this application is being brought forward.
Okay, well, I'll weigh in, and I'm inclined to agree with Mr. Clay that deferral is the best way to go. I mean, council is looking at preserving heritage in this city, and they want this looked at, and I think that should happen. And once it happens, that it then can come before us and be looked at in a more appropriate manner, depending on what that board decides in terms of designations. So I would be also in favor of deferral.
I think, if I'll just add one more thing, I think basically what we're doing now, if we were to make a decision to approve or deny, I think it's a hypothetical approval or denial, right? Without the heritage information being complete. And yeah, I have a problem with that, but I can get myself there conceptually. But if in the absence of, if we're going to go ahead and it seems like there's support for a deferral, and we all supported a deferral at the start. I would support a deferral as well, but
I was under the impression when the applicant didn't want us to take the deferral vote at the beginning, that deferral was off the table. and that they wanted us to make a decision either in favor of or in opposition to the application, which is where my particular proposal came from. I don't have difficulty supporting a deferral, but I'd like the deferral to indicate the reason. And it seems to me that there are a couple of reasons. One is to allow us to evaluate the analysis that's going to take place on heritage designation. And the other is for the applicant to deal in a cooperative way with the neighbors to try and address concerns. Having this come back as exactly the same application, with there having been no consultation with the neighbors and no consideration of an alternate to the integral garage, seems to me a waste of time. So providing the deferral gives an opportunity to try and address the concerns of the neighborhood and also look at alternatives to the integral parking, I would have no trouble, but just a deferral of the application so it can come back in its similar form, I think is a waste of time.
I think that's a really good suggestion, Carl, and you know, these are the sorts of things that should happen regardless of whether we defer or not. There should be appropriate discussion with affected and adjacent neighbors. So it sounds like we have a bit of a consensus. So in that regard, I will put forward a motion that this application be deferred, subject to the committee, whichever committee it is, benefiting from the decision from CRB, and put as a condition, or at least make a strong suggestion, that when the applicant returns to committee, that they would be able to show evidence that they've had some discussions with surrounding and adjacent neighbors.
Okay, and also that they address the integral garage concern expressed by planning and by the members.
I think that would be in their interest to do that, yes.
Okay, so we have a motion before us, moved by Mr. Clay.
I'm happy to second that.
Yeah, okay. Moved by Mr. Clay and seconded by Mr. Nipfel for both items 20 and 21, so 40 and 44 Mitchell, to defer this item. And if the staff can please note in the decision that there's an expectation that consultation take place with neighbors, that the integral garage be revisited and something alternate be done, and that it doesn't come back until the CRB has made their decision after September 10th. Okay, so with that, all in favor? Okay, so the matter's been deferred.
Just to clarify, it's not a decision, it's a motion to defer, which was now approved unanimously. So
Yep.
a decision was not made.
Yeah, it's a deferral.
Thank you.
So when would the deferral be heard?
Well, when after the CRB decisions are gone through, and I'm not familiar what the processes are, I don't know if there are appeal periods associated with it. Maybe Deputy Secretary Treasurer, can you maybe address that?
I'm not sure. I think it's a provincial matter now because there was no agreement made on that. So it would be to determine the results of the heritage status prior to being rescheduled, further consultation with the concerned neighbors, and reconsidering the integral garages. So until a decision is made on the status of the property, we can't reschedule your application, but you also do, once that status has been determined, you'd have to consult with the neighbors depending on what you can do with the properties.
Okay, and maybe between now and the CRB hearing, you could talk to planning about their issue with the application. All right, thank you very much, everyone. The next item is item number 22, 65 Glen Manor Drive. We have before us a copy of the plan of survey, site plan, floor plans, and elevations, a covering letter from Christian Chan, the agent, as well as planning rationale and presentation materials. We have email correspondence from transportation planning. I don't believe there are any conditions. We have a letter from the local councillor who's in support. We have support from number 77 Drayton, 2301 Queen Street East, 29 Winter Circle, 338 Lee Avenue, and 28 Glen Stewart, as well as a two-signature petition in support from 101 Glen Manor. And we have opposition from number 4 Avalon Avenue and 105 Scarborough Beach Boulevard. Now, do you have the 1, 2, 3, 4 speakers?
So through Madam Chair, I called Paul Nagy, who wasn't in the hearing room, and he did not answer, so he's not here.
Okay.
And I called Mark Kuhlman, who answered but then chose to leave, and he is not currently in the room. So
Okay.
Michael Brett and Michael Adams are here, and I'm not sure if Sherry Vander Kooi is related to the application or in
Yeah, I
speaking
think, well, it
opposition.
looks, she's listed in with the principal and co-owner. I'm not sure if that's,
Yeah.
assuming that's correct.
We'll ask.
Okay. All right, do I have the agent on the line?
Good afternoon, Madam Chair and committee members. This is Christian Chan from C2 Planning.
Okay, I have speakers in opposition, so if you could do a presentation no more than 5 minutes, and we're starting the clock now.
Great, thank you, Madam Chair. And I just want to confirm that yes, Sherry Vander Kooi is the operator of the Avalon Montessori School.
Okay, thanks.
So they are online just in case there are functional questions of them pursuant to the presentation and for any of the objecting residents nearby. But going into it, so we are the land use planning consultants for the owners of the above of property, trustees of the Beaches Presbyterian Church, as well as the applicant, which is the Avalon Montessori School. So the Avalon Montessori School is operating nearby about 500 meters to the west at 2181 Queen Street East. They were located there for 10 years. There was no parking on that site, and the site was heavily used or accessed by transit. Avalon, prior to that 10 years, was located in at the Beaches United Church, also in the local neighborhood. Avalon currently operates a preschool program in the existing church, in fact, at 65 Glen Manor Drive. The reason for seeking the approval from the COA to use the basement is that the lease for the previous school at 2181 Queen Street East had expired, and the landlord did not renew the lease. So Avalon was scrambling to search for a new location, and the church agreed to a 10-year lease, providing the use of the basement to Avalon. So the reasons for the zoning permissions are for that Toronto Buildings, upon zoning examination, sought that the school is actually a use that required permission from the Committee of Adjustment to use it as such. So the school, the existing student population is 45 elementary school level pupils. We're expecting to return to classes in September. So the area of work in the basement is approximately 583 square meters. There's going to be 5 new classrooms as well as an office and storage space. No exterior alterations are proposed. No other changes are proposed. The existing church on the sanctuary on the main floor are going to be used as such, and no affectations to the proposal for parking spaces or other uses on the site are going to be affected. So we've spoken, in terms of consultation, we've spoken to Councillor Bradford's office regarding the proposal, and we understand that the councillor has submitted a letter of support for the proposal as well. We have spoken to Mr. Santiago of City Planning, who's informed us that they have no objections to the proposed use or the parking space variance. As you mentioned, Madam Chair, Transportation Services has raised no issues with the proposed deficit in the parking spaces for the proposed use. And also the applicant has spoken to and reached out to surrounding residents also in response to the objection for number 48 Avalon. Just to a little bit to context, the church has a preschool daycare operating already in the portion of the basement floor area. And just to also note on figure 3, before you here, there is an existing 10-minute student pickup and drop-off area directly in front of the church and along Glen Manor Drive. So parking facilities are already provided for that can accommodate the private school use. There are approximately 4 or 5 parking spots that are available for student pickup and drop-off. Also to note that many of the students, as I have been informed by the operators, walk to the school or dropped off by pedestrian or bike to the school, and also that this Queen East streetcar stop is approximately 87 meters away from the entrance. So with regards to the variance, the proposed use in the basement is complementary to the overall existing of the building. It already has a preschool use in the basement for 22 years. And regarding the parking, again, there's a 10-minute student pickup and drop-off area. And then also that many of the students live within walking distance of the subject site, and this is approximately 5 minutes away from the former location, so it's not a big shift in travel patterns, active transportation travel patterns. So there are other integrated private schools with churches that exist in the neighborhood, such as Fallingwood Presbyterian Church. Also, in respect to the official plan, policy 4.1.1 provides that within neighborhoods, low-scale local institutions such as these schools are an integral part of everyday life. So the proposal to permit this use, in my opinion, will not disrupt the overall built form and function because there aren't exterior changes and conforms to the institutional school uses contemplated in a neighborhood's designation. So
Okay.
making good use of the existing student pickup and drop-off area is desirable in this instance as well. And how much time do I have, Madam Chair? I think I'm all
20
set.
seconds.
Okay, and just to speak to the concerns of the neighbor at 4A, we had sent on July 20th, yesterday at about, it's timestamped at 3:04 p.m. If the committee staff could put this up, a response from the operators of the school to the concerns of the neighbor to the east with respect to concerns for traffic in the laneway, children in the laneway, noise, and outdoor spaces and the like. So I can address those things in response to the other deputants.
Yeah, that would be great. Okay,
And thank you, those are my submissions.
all right, thank you. So we'll have you back after we hear from the two speakers. Mr. Brett, are you there?
Yes, I'm here. I'm the trustee of the church. I really don't have any particular comments to make of a technical nature, but just to note that as Christian has said, we anticipate that the Avalon Montessori school will actually be of a benefit to the neighborhood. Our church building is both to us a blessing and a curse because we need to maintain it. And by getting good use from the available floor space, we're able to maintain the church. And we do in fact serve other local organizations in the neighborhood that are able to take advantage of what we have. That's really all I just wanted to stress.
Okay, thank you very much. Mr. Adams.
Actually, Kathy Shum Adams. I'm the wife of Michael Adams.
I'm sorry, did you say Kathy Shaw Adams?
Shum Adams.
Kathy.
I think we're both logged on.
Okay, alrighty, you have 5 minutes, starting now.
Okay. So Michael and I are the property owners of 4A Avalon Avenue, but for everyone's information, our home abuts the private share laneway with the church, which is under 5 meters wide. And so it is for this reason, we are the ones who are most impacted by the variance being discussed today. I understand that Councillor Bradford has submitted in a letter of support. We feel that his situation is one-sided and incomplete, because he failed to gather feedback from the residents who will be directly impacted from the disruptions. Same thing with the church. The church only reached out to us after they have begun construction for the school last year, and after Avalon School has listed their address at 65 Glen Manor Drive. So the reaching out to support by the church and the school, that's done all after the fact. So, the church, we've outlined all our concerns in our 4-page letters plus the 2 exhibits, so I don't want to get into that again. But just to say that the church has failed to act as a good neighbor, as it does not duly consider all the consequences before making vital decisions that has an impact on its neighbors. I have examples, but in the interest of time, we don't have, I won't be going into that. We stated in our submission the various zoning bylaws for an institutional school. We believe the main purpose of these bylaws is to provide privacy and physical separation between a school and a residential area. We would be interested to hear if these rules apply. Two things to note as well is Christian touched on the pickup and drop-off zone located on Glen Manor Drive, but he failed to mention that the pickup time and the drop-off times need to be extended. Because if you look at the times right now, the school begins earlier and ends later than the preschool. Because that drop-off is for the preschool. Secondly, we understand that the church is being used for a whole bunch of other activities, community activities, and so we are concerned, and we'd like to ask the committee to consider if the church can provide sufficient parking for itself, its tenants, and all the aforementioned community activities, scouts, guides, fencing, yoga, recording musicians, and so on. Otherwise, trespass will ensue as outside of the laneway will be taken by parked vehicles. And in the last 20 years, on and off basis, we have been dealing with what's outlined in the letter, with the noise, the garbage, and the traffic from the now defunct dance school. And we feel that this is a time for us to log in our complaint on a formal basis with the city. Now, having said all this, we're neighbors. It gives Michael and I neither comfort nor pleasure to see the church fails in its endeavor to secure an anchor tenant. So we are prepared to support the proposed variance insofar some of the conditions are met. And I'm sorry, but we haven't read the letters submitted by the school, I guess, yesterday. So the conditions that we're outlining here, we'd like to put forward can minimize, although not completely eliminate, the noise, the disruptions, the traffic, the trespass associated with the school having so close to our property. The conditions are as follows. A, the students do not use any of the entrances located at the rear of the church in the share laneway. They can, however, be used as a means to get out of the building if necessary during a fire drill or an emergency. B, the students cannot make use of the laneway at any time or for any reason, such as, and not limited to, lunch break, recesses, or any extracurricular activities. And C, parents will not be allowed to use the laneway as a pickup or drop-off area. I know Christian touched on a lot of our concerns, but in reality, when we have the dance school here, parents do come into the driveway and park and drop off their kids. They do use it because it's there. Even though there's signage being posted by the church that it's private, people do not respect that for whatever reason. So we need reassurances these restrictions are set permanently in place, that it's legal and binding in case a different school moves into the church at a later date. We also need to understand what mechanism will be put in place to ensure the rules are followed and what recourses we have as property owners if such rules are violated. And if a variance were to be granted, a complete list of deviations and variances that are being waived so we can gain a better understanding of the process.
I have to ask you to wrap up, okay? You're at 5 minutes now, actually past 5 minutes.
Okay, so to wrap up, I'd like to say we need to look to the future, to a post-pandemic world, which is what everybody has been waiting for. We understand the enrollment is roughly 40 children today, but that number may grow if the school continues to flourish. So if we don't address the outlines, or don't address the issues outlined in our submission now, the problem will only get worse. Thank you.
All right. Thank you very much. Panel members, do you have any questions of the speaker, Mr. Nipfel?
Could you tell me the ownership of the laneway? Is it a right-of-way that you and the church have rights to use the whole laneway, but you have right-of-way issues on it? I mean, who owns the actual laneway itself? If we look at the site plan, maybe we could use the site plan for reference.
Hi, this is Michael Adams. The laneway is owned, I believe it's 2.29 meters, Avalon owns. The church owns 2.29 meters of the other half of the laneway, and we each have a right-of-way. In addition, our houses are built on a former land that the church owned, so there's actually 4 semi-detached houses. All of them plus the church have right-of-way on the laneway. And I'd also like to point out, when the church sold the land, they they sold the maximum amount of land, and they could have at that time retained a private driveway, and they didn't. And at that time, there was an existing full-time daycare, all-day daycare, that had to move out because of loss of playground and perhaps the parking lot that was gone.
And there's no, just to clarify my understanding, there's no parking on the church lands, as I understand it, and I understood from the lady that just spoke that there's no parking permitted signage along the laneway. Is that correct?
Yes, we have signage in the laneway, not to park in the laneway. Over the years, the dance school, which, by the way, the church did not have proper zoning for, the parents often ignored this. They were quite combative, some of the people saying it's public space, they have a right to be there, they're just dropping their kids off and whatnot. We had huge issues with the church initially, and because the dance school was using the rear doors. And
okay, and the drop-off area that it was referred to by the applicant is on Glen Manor, and it basically
Yes.
that's just it's a reservation that you can't park between certain hours to allow for drop-off. Is that correct? And the adjacent owner mentioned that that's fine, but that the hours need to change.
Yes, the hours need to change, and I'm not sure if that means another zoning meeting or not, because that impacts the neighborhood parking, obviously. But yes, the hours, I think the latest hour is like 2:45 or something. So it's not late enough for a school, and I think at the first started was 9:15, which isn't early enough for a school, right? So the hours don't really, they're good for the preschool, but not necessarily good for a private school. And I don't know how late the school goes.
My understanding of the dance school would be that the school probably operated in the evening, after school hours, whereas, as I understand it, the Montessori school is a preschool and a day school. So I guess this is a question for the applicant, is the entrance to the area that's going to be used by Montessori, is the entrance logically from Glen Manor? I can understand parents dropping their kids at the dance studio off in that laneway if in fact the dance studio's main entrance is off of that lane. I would like to understand where the main entrance to the Montessori school will be.
I can answer from our perspective. Originally, the school was probably going to have two entrances, one off of Glen Manor and one off of the laneway. And we know this because I overheard a conversation between the principal and the contractor, as well as the church administrator, Elizabeth Grant, told me that the older kids would be using the rear entrance into the basement. If you look at the floor plans, there is I guess you would call it a coat and boot room that's at the back off the laneway for them to store their coats and whatnot. So it's a natural entrance and exit point, more so than the other entrances in the front entrance. So our concern initially is, we had initial problems with the dance school. The church was ignoring this and going back and saying, okay, well, they can use the rear doors, this new private school. And so this, was quite a shock to us because we had so many issues. Our issue is, okay, today they can say we're going to use the front door. 2 months, 6 months, a year later from now, what is to stop them from starting to use the rear entrance door from the basement, which is a much more natural for two of the classrooms, to use that. And once that happens, parents are going to be dropping off the children into the laneway. And if you start dropping the kids off into the laneway, they start entering, they're going to congregate into the laneway before and after class, in between class, lunches and recess. And it's just a natural playground for the children because there is
Okay,
no space
I'm
for
sorry.
playground.
I'm sorry to cut you off, but we need to stick with the question. And I don't know, Carl, did you get an answer to your question, or do you want to get it from the
Yes.
applicant?
No, it was very helpful. Thank you very much.
Okay, thanks. Okay, panel members, do you have any other questions of the speaker? Okay, so Mr. Chan, are you there?
Yes, I am, Madam Chair. Thank you.
Okay, can you speak to the issues that were raised? I do want to say that some of these things that I saw in the submission, cleanliness, noise, those are all municipal licensing and standards. They are not within the purview of this committee. And with that, I'll give it to you.
Yes, thank you, Madam Chair. I was going to mention that as well. With regards to property standards and noise, it is in the purview of MLS to deal with these things. Just providing a little bit of background, the previous church encompassed the properties numbers 4A to 6B, so there was a yard that was already attributed to the church and a parking lot that backed onto number 8, number 10 Avalon, if we can go to the map overlay on the public notice. So these impacts with regards to children playing were already there, as well as traffic impacts. Now, since the church was sold the properties, the eastern half of the property to create additional residential units, now we're faced with a situation where these residents are now taking issue with something that existed for number 8 and 10 for a number of years at the construction of the church. So I can certainly appreciate the concerns of the neighbor at 4A. I can confirm from the school operator that the entrance to the school will be from Glen Manor Drive. A document that I submitted yesterday at 3:04 p.m. A date stamped to the committee explains a number of these factors that will address their issues, and by all means, it is the intent of the operator to not have that laneway used for regular egress for the students, namely only for fire drills or fire egress, and also for not any parking, provision of any parking or drop-offs for the students. I'd also like to note that the intent of the operator is to have drop-off in the morning in front of the school. However, as outlined in the July 20th document, the pickup will occur at the park as the students after school will be walked down to the park, whereby they will be picked up or walk home from there. I'd just like to also address the sign for parking student drop-off, the hours. I could certainly coordinate with the counselor's office who has been involved with this to see whether the counselor would provide an amendment to the hours of that parking, because I believe it is a decision of community council that would have to be made to alter the times for the drop-offs. So we'll proceed with that, especially with regard to any decision here. I'm just looking at my notes here. With respect to the number of pupils in the building, that's an Ontario Building Code issue, so the number of students will be limited to the fire code and the building code in the building. So the intent of the operation of the day school is to have 45 students, and I don't expect that to increase without having to seek approval from the fire department or from Toronto Buildings. I'm just going to go through a document that the operators provided for me. So the children will be dismissed at the end of the day to the nearby green space, Q Park. So parents will not be congregating and picking up the children at 65 Glen Manor at the end of the day. They intend to notify the parents about proper drop-off protocols, which do not include the laneway between the properties. They intend to place pylons at the end of the laneway to block cars from entering it. And also they intend to have a staff member at the bottom of the laneway for the first few days of school to remind parents just in case. With regards to children in the laneway, they will enter from the front door. They will not enter from the laneway. The laneway has to be used for fire drills once a month. They will have the children and staff exit or enter through the main doors for recess and gym class. The gym class and the recesses are held in the local green spaces, will not take place in the laneway. And of course, just with regards to noise, they will not have children playing music in the classrooms or loudly like a dance school would have done. And the classrooms are for schoolwork. And it's stated in the document too that the school will care about their neighbors and will work to keep the noise to an acceptable level should they be having any special event. And they will not have their children congregate in the laneway because this is also an issue for fire egress. And if this committee does have this document, it is submitted as part of the public documents here. But should there be any conditions with regards to the use of the laneway, I've discussed this because my clients have reached out to the owners of 4A and said if there are any conditions that the committee desires to impose with regards specifically the laneway in terms of use and children in there, then that would be acceptable to my clients to include in the decision.
Okay, thank you. Panel members, do you have any further questions regarding this application? Seeing none? Okay, we'll take it into committee then. Any comments? Mr. Nipfel.
Mr. Chairman, or Madam Chairman, I don't think there's anyone that would be opposed to the actual use. I think this is something that's quite needed in this and all neighborhoods. The drop-off and parking is an issue that accommodates or accompanies this kind of use. It does sound to me as though the owner, in this case the church, and it's the operator of the school, are well-intentioned to try and solve any outstanding problems. The pylons on the laneway, the information to potential customers, the potential extension of the drop-off times along Glen Manor, all sound to me to be reasonable. There was, Madam Chairman, a suggestion earlier in this meeting with another daycare that they were going to provide handout material to all the users of the daycare advising where parking was and was not permitted in the area, and I think if something similar could happen here, that would also be advisable. Having said that, Madam Chairman, I think the applicant has done everything reasonable to accommodate the use in an existing neighborhood and to try and offset any difficulties of parking and drop-off. On that basis, Madam Chairman, I don't think that this is going to be a problem for the community. I think there's well-intentioned cooperation here to make sure that this works and it works in harmony. So I would like to bring forward a motion of approval without any conditions.
Alrighty, do I have a seconder for that motion? Mr. Reid? Okay, motion to approve, moved by Mr. Nipfel, seconded by Mr. Reid. All in favor? Your application has been unanimously approved. Thank you, everyone, for your input. Okay, the next item is item number 23, 57 Rhodes Avenue. We have before us a copy of the plan of survey, site plan, floor plans, and elevations. We have, let me see here, Forestry is asking for condition number 3. Planning is asking for a condition regarding screening, and transportation also has a condition. We have support from both adjacent neighbors at 55 and 59 Rhodes Avenue. Do I have the agent on the line?
Good afternoon, Madam Chair and committee members. My name is Mr. Zafar, and I'm the agent for the homeowners at 57 Rhodes Avenue.
Okay, panel members, I don't think we need a presentation. Do you have any questions for the agent? Okay, Michael, we don't have any questions. We've read all the materials. We're ready to go into committee to make a decision. Is there anything you want to add? I do see that the owners are listed. I'm assuming you're speaking on their behalf.
That is correct. As long as committee doesn't have any questions for me to address, I'm okay for the matter to go into committee.
Okay, thank you. Okay, panel members, let's take it into committee for a decision.
Madam Chair, I'm happy to jump in. I think this is a well-designed house, and I think with the planning conditions related to the screening, I think that takes care of any overlook. But this is relatively modest, and I think it fits in with the pattern of development and the existing homes in the neighborhood, and I don't see any negative impacts coming from it. So I'm going to put forward a motion to approve, subject to urban forestry condition 3, community planning's condition in the July 14th report, and the transportation condition of July 14th.
Okay, with those conditions, Mr. Reid's moving approval. Do I have a seconder? Mr. Nipfel. Okay, so that motion carries. All in favor? Actually, I'm a little ahead of myself here. Okay, so that carries unanimously with the 3 conditions that were outlined by Mr. Reid. Okay, The next item, item number 24, 379 Shaw Street. We have before us a copy of the plan of survey, site plan, floor plans, and elevations, and correspondence in support from number 368. And I do not believe there are any no? Okay, Robin Beek, okay. All right, Mr. Donato, are you there?
Yes.
Okay, just identify yourself for the record, please.
Peter Donato.
Okay, and Robin Beeg, I guess, is that part of your
My wife
team?
is not available.
Ah, okay.
Yes, she's my wife.
Alrighty, panel members, I don't think we need a presentation. Do you have any questions? No questions? All right, Mr. Donato, we've read all the material. We have no questions. We're ready to take it into committee. Is there anything that is outside of what we already have that you want to add before we go into committee?
No, and I'm just observing my representative, Andy, should be on the phone too.
Sorry, I didn't catch that. You were observing?
I'm observing only. My representative, Andy Trotter, should be on this call.
Oh, really? I don't have him listed
He
there.
didn't register,
He
so
didn't.
we didn't have him here.
He's
Okay,
not,
well, that's fine.
yeah, he's not registered.
He is in the hearing room.
Okay, go ahead. Hi, Mr. Trotter.
I'm sorry, I have the next one too, so I got confused with my WebEx registration, because I'm actually doing 379 Shaw and then 42 Noble. So I apologize for that mistake.
No worries. In any case, you probably heard that we've read the material. We're ready to go into committee unless there's something that's, you know, that's not listed.
No, nothing to add. Thank you.
Okay. All right. Thanks. Okay, panel members, we're in committee. Mr. Niffel.
Madam Chairman, I believe that the proposal before us is in keeping with the character of the neighborhood. It's a very minor adjustment, a small internal work, and a front walkout. There is a walkout a few doors away. I don't find that therefore that the walkout is in any way inconsistent. I'd like to move approval without conditions.
All right. Seconder, Mr. Clay. All right, moved by Mr. Nipfel, seconded by Mr. Clay to approve the application, no conditions. All in favor? Your application's been unanimously approved. Thank you. Item number 25, 42 Noble Street. We have before us a copy of the plan of survey, site plan, floor plans, and elevations. We have a staff report from Forestry asking for condition number 2, and we have opposition correspondence from number 10 Strickland, basically saying that there are too many variances. And yeah, I don't show any speakers. So Mr. Trotter, I guess you're back with us
Yes,
again.
it's Andrew Trotter. I did register for this, certainly.
Yeah, I see. I've got you on this one. Okay, let me see if I don't think we need a presentation. Let me see if there's any questions. Panel members, Mr. Niffel.
Very quick question. Do you have the support of 40, which is the attached semi? I don't see it in the information.
I have the support in a text message I got from the owner, from the neighbor. He sent a text saying that he would send in an email of support. I went to knock on his door to confirm it. I didn't get a hold of him, but he did give a verbal and a text support of support.
Okay, that's fine.
Yeah.
That's great. Thank you.
Yeah.
Any other questions, panel members? Seeing none. Okay, Mr. Trotter, same thing. We've read the material. We're ready to go into committee unless there's something you'd like to add we need to know.
No, nothing to add.
Okay, panel members, we're in committee then. Any comments?
I'll start. I thought this one, again, was fairly straightforward. The area is of a fairly tall buildings, high density already. The property itself is adjacent to a laneway. I don't think there'd be any particular negative impact on that side. And if he's got the support of the adjoining semi, I think that sort of speaks to whether there'd be any kind of major over concern. I thought the variances themselves, while numerous, are all quite minor and often related to the kind of development they're proposing on a semi. So I think there is forestry number 2. So if my colleagues don't have anything to add, I'm happy to make a motion to approve this application subject to forestry condition number 2.
Okay, panel members, that's the motion. Mr. Reed, you're seconding. So motion to approve, including the forestry condition. Moved by Mr. Clay, seconded by Mr. Reed. All in favor? Your application's been unanimously approved. Thank you. Item number 26, 29 Mcpherson Avenue. We have before us a copy of the plan of survey, site plan, floor plans, and elevations. We have a covering letter from VFA Inc., the agent, an arborist report, revisions to the post-public notice, correspondence from the owner, as well as reports from community planning. They're asking for a condition. Forestry's asking for condition number 2. We have support from number 27, adjacent property, as well as number 12, Roxborough Street West. We have opposition from number 31, 18, 10, 33, 37, and 45 Mcpherson, as well as number 12, number 18, number 28, and number 14, Roxborough Street West. Okay, do I have the agent on the line?
Yes, Matthew Lawson from VFA Inc. on behalf of the owner.
I'm going to need you to do a presentation, but before we do, I just have one question. I think I read somewhere that you're going to 1.13 on variance number 4. Are you actually revising that variance, or is it staying? I think it's at 1.1.
That's correct. The revised plans that were submitted dated July 14th, and I believe there is an accompanying revised zoning notice that reflects those drawings. Note an FSI of 1.13. That's correct.
Okay, so are you amending that variance then? And if so, can you give me the square meters also?
Yes, if you give me one moment. We are amending that variance to an FSI of 1.13, and the revised GFA number is 230.36 meters squared.
230.36 meters squared.
That's correct, yes.
Okay. And just to confirm with staff, do we have those plans? Are they like with the staff? Are they with the planning report? Sorry, or is it what we actually have? Yeah, must be. Okay. All right. So if you can do a presentation, we'll start the clock now, so no more than 5 minutes.
I do have presentation materials on file as supplementary information.
Hang on, I'm just looking here. Maybe is it in the sub? Yeah, we have it. Is there a particular page you want us to put up?
If we can start on the first page, that'd be great.
Okay, all right, so we'll start the clock now. Go ahead.
Sure thing. So the proposed development for 29 Mcpherson involves the renovation of an existing 3-story semi-detached house, an extension of an existing rear addition, and the construction of a new garage accessible from the municipal laneway at the rear of the property. The property is on the south side of Mcpherson Avenue, just west of Glen Street. We are seeking relief from the following provisions of the zoning bylaw. For front yard landscaping, where no work is proposed, but in order to regularize the existing conditions, In short, nothing is changing in the front yard, but the existing condition is deficient. Building depth. The existing rear addition results in a building depth of 18.13 meters, whereas 17 is permitted. We're proposing that the reconstructed rear wall maintain the existing building depth, i.e. project no further into the rear yard. On the site plan shown here, the extent of the existing rear addition is shown as a dashed red line for reference. Rear yard soft landscaping. We are proposing that the existing soft landscape coverage be maintained in a revised configuration. We have correspondence with Ryan Santiago at Community Planning and have worked with them to resolve concerns about this existing deficient condition. We'll note that that was the only concern which Community Planning expressed regarding the application. We understand that they've recommended the inclusion of 34 square meters of green roof area as a condition of approval in order to mitigate concerns regarding stormwater management. We support the inclusion of that condition in the event that the committee moves to approve the variances. For FSI, the existing conditions at 29 Mcpherson represent an FSI of 1.04 relative to a proposed FSI of 1.13. In absolute terms, this represents an increase in GFA of approximately 16.24 meters squared, whereas the zoning bylaw allows for 0.69. We've compiled, on the second slide here, adjacent committee decisions that reflect both comparable FSI numbers and building depth to illustrate that the variance being sought is both incremental relative to the existing conditions and contextual to the area. As a further note, the adjacent houses along the south side of Mcpherson Avenue between 27 and 51 share a common architectural expression and have comparable FSI values of near or exceeding 1, illustrating that this is in line with the existing conditions and not simply recent approvals. I'd also like to address some of the concerns expressed by neighbors regarding the existing mature trees on the property at 29 Mcpherson, as well as the neighboring property at 31 Mcpherson. We've retained an arborist, and I believe their preliminary report and a subsequent supplement is included on the file. And in coordination with urban forestry, we've undertaken investigation on the site to ensure that the proposed work will not cause intolerable injury to the trees. We have no intention of causing serious injury to the trees and understand that urban forestry would not permit that. We've considered the proposed structure and work in order to minimize any impact on these trees. Finally, we'd like to note that we have consulted with the neighbors at 27 Mcpherson and 31 Mcpherson prior to the formal notice period, and in response to specific concerns expressed by 31 Mcpherson following meeting June 15th, have made several revisions that are reflected in drawings dated July 14th. This was the resubmission that was referred to. Specifically, the previously indicated side yard setback has been increased to comply with the required 0.9 meter side yard setback, which would make it in compliance with the zoning bylaw. We've also made several changes to the proposed development in consideration of their concerns, which are not strictly related to the variances being requested and under consideration today, illustrated on the next two slides. These are related to providing an additional side yard setback on the second floor for the portion of the building exceeding the permitted building depth, reducing the height of the reconstructed rear addition, reducing the height of the proposed garage, reducing the extent of the proposed rear canopy projection. We'd additionally like to note that we do have support of the attached neighbor at 27 Mcpherson. We've made significant efforts to have these changes reflected in the materials being considered by committee today, and believe that the proposal represents an incremental and contextual increase in density, and that the variances requested are in fact minor. Thank you.
Can you confirm if you're deleting variance number 2? Because looking at the revised zoning review, there are only 5 variances.
Yes, that's correct. We're no longer seeking a variance for side yard setback.
Okay, you should have advised of that at the beginning when you were making your modification.
Okay, so variance.
My apologies. That was confirmed in the updated zoning certificate and previously in correspondence with the
Yeah, the problem is that we still have the original notice in front of us, so, okay, so we're
Okay,
deleting
understood.
variance number 2, which is that the semi-detached house will be located 0.86 meters from the west side lot line. Is that correct?
That's correct, yes.
Okay, so we're deleting that one and we're amending number 4 as we discussed earlier. Okay.
Yes, that's correct. Thank you.
Okay, I'm gonna go to the speaker I've listed and then I'll come back to you for any rebuttals. Thanks.
Madam Chair,
Yeah.
the speakers listed, someone's representing 31 Mcpherson and then the speakers.
Yeah,
are for
I see that.
31.
I was gonna ask the, for clarification on that, cause I wasn't sure if these are tenants or how it all fits together, so let me find out. But thanks for pointing it out. Okay, Ms. Kleinfeld, are you there?
Yes, I'm here. I'm an agent actually for the owners at 31.
Okay, so you are actually speaking on behalf of Elizabeth Kuster and Stephen Bowman.
Well, I believe Stephen is also asked to speak to this, so
Well, in
there
that,
are two of us.
Okay, so in that case, I need you to split the 5 minutes between you, because it's usually like 5 minutes per address, so it doesn't matter to me how you do it and who wants to start off, but you tell me, and once you decide, I'll start the clock.
I thought the understanding was 5 minutes per person. Certainly on other projects we've been looking at this afternoon, it's 5 minutes per person.
No, it's been 5
It
minutes.
is, but if you're representing them, then you're speaking on their behalf. So they can choose, do they want you to represent them or do they want to speak on their own?
That's unusual. I'm not clear on that ruling, but I suppose what I can start and do 2 minutes and Stephen can do 2 minutes. I think that the largest problem that we're having, and right now you have the massing diagram on the screen, and I think that that's the biggest difficulty that we have. They are grandfathering some of the existing GFA excess, and they're adding to that. So the difficulty we have with that is that it becomes quite a looming mass at the back of the house. And this is not in keeping with the rest of the neighborhood. We would concede that this mass is excessive. Although the people at 31 have accepted an increased GFA on the first floor, they have asked for a setback to the existing west setback that is there now. And that hasn't happened. It's only gone back a bit and not in its entirety on the second floor. And therefore, we're asking that the second and third floor not have additional GFA added in terms of moving westward towards 31. It is quite a large volume at the back of the house. We're not contesting the garage addition. We're not contesting the first floor to come to the western boundary, but the second and third floor are pretty much a no-go with 31 because of its intrusion on their property. It's really going to affect their light, and also it's proposed to be a white stone, which is something they're not going to be able to ignore either. So for those reasons, they're asking for that. There is no easement between the two properties, and the report from zoning has said that there would have to be an easement in order for 29 to go between the houses out to the street. So we're asking, how does the garbage disposal work without that easement? And the trees, we have not received anything from the urban forestry as to their acceptance of the arborist report. So because we don't have that, and the new drawings were submitted last Thursday, so the neighbors have not been able to have a look at them, we were initially asking for deferral. And I think we're still asking for that deferral based on the fact that there are new drawings which are basically the same as what was submitted before, and we're asking for that on the basis of no new zoning report that has been seen by any of the neighbors. I haven't seen a new zoning report, and I haven't seen a new urban forestry report. So those two things are very significant, because the suggestion is that the arborist's suggestion is that 3 of the roots of the mature tree on 31 Mcpherson be cut off. And we have no idea. We're not forestry people. We don't know if that's acceptable or not.
Okay, just a heads up, you're at 3.5 minutes.
Okay, Stephen?
Stephen Bolt. Thank you. I think I'm on now.
Yep, you're on. Just identify yourself for the record, please.
Oh, I'm Stephen Bowman. I'm with my wife, Elizabeth Kester, and we reside at 31 Mcpherson, which we have lived in and owned since 1988. In that time, we've had 4 previous neighbors in that house. 3 out of the 4 had children and raised families. When we acquired our house, the existing addition that's there today was there at that time. At that time, it was the largest house in the neighborhood because of that existing addition, and this proposal will make the existing largest house larger. Carol has referenced the elimination of the side yard where garbage cans have always been kept, and we're puzzling over where the garbage cans will go later. But we also wanted to point out that we recognize you have to balance the character of the neighborhood, the legitimate interests of the Goulds to develop and use their house, and our use and enjoyment of our house. 8 of the neighbors, apart from ourselves, have objected to this. One of the 2 people who endorsed it, number 27, have told us that they're selling number 27 to the Goulds, and the Goulds have told me that they plan to move in during construction. So there's very little support for the broad proposal. All that having been said, we understand that things change, but we already do live next door to the largest house in this little neighborhood. And we understand the balancing act that has to take place, and as Carol has explained, we ourselves can get comfortable with this, with the second floor setback, so that the dominance of the property is scaled back, even though the footprint at ground level, subject to the trees, is expanded as they've hoped. So that's where we are.
Okay, thank you very much. Panel members, do you have any questions of the speakers? Mr. Niffel? You're muted.
Sorry, thank you. My question is to Mr. Bowman. I'm not completely clear on your last point. If I understood, you're fine with the ground floor. You're not supportive of the second floor extension. Have I got that correct?
That is correct. Yes, that's the case.
Okay, thank you.
Any other questions of the speaker? Either one of the speakers? No? Okay. I guess we go back to the agent then. I'm not really sure. I guess address the concerns that were raised by both the neighbor and the neighbor's agent.
Sure. Maybe I can try to touch on some of these. With respect to the trees, as I said, our understanding is that urban forestry does not support injury of these trees, significant injury of these trees. I believe they've recommended a condition be attached in the event of approval.
Yeah, they have.
Which
number 2.
We are more than willing to accept. Like I said, our intention is not to cause any lasting injury to the trees, any significant injury. With respect to, I guess, the easement and the functioning of the side yard condition, you know, I can only say that the kind of pinch point, for lack of a better term, is between the closest points of the existing building still. That is not changed, and my understanding is that both 31 and 29 both have you know, functional use of that in order to dispose of garbage, for convenience, for access to their rear yards. With respect to GFA on the second floor, and I guess the kind of side yard setback, or the additional side yard setback that we've provided, that somewhat splits the difference between the extent of the ground floor extension and the existing location of the sidewall. I think that, you know, we feel that this represents a reasonable compromise between, again, the existing condition and what was originally proposed. And again, I think that based on the context in the neighborhood, we have a couple of decisions from the area that have comparable FSI, that combine, you know, comparable FSI and building depth. And, you know, again, we feel that this is minor in nature and is both incremental and contextual.
Okay, panel members, do you have any questions for the agent? Seeing none? Okay, let's take it into committee then. Any discussion?
I don't mind starting off. I appreciate that the applicant has worked with the neighbors, at least some of the neighbors, to create a product that's more acceptable to them. I think that's a good place to start. I think this is a good application. Keeping in mind the variances, this only is an increase of 16 square meters, and that's not a huge thing. And despite the fact that this is one of the larger homes on the street, I think this additional space that they're putting into it has been done sensitively and is not meaningfully increasing its impact on its neighbors. So I'm going to be supporting it. And if my colleagues don't have anything else to add, I'll happily move for approval subject to community planning's green roof condition and urban forestry condition 2.
Okay, and it would be the application as amended, removing variance number 2 and amending variance number 4 to read 1.13 and 230.36 square meters.
Yes, 230.63 or 36, whichever.
I thought it was 36, but yeah, 36.
Okay.
And
yeah, exactly.
I'm sorry, Carl, did you want to say something, or were you just seconding this?
No, I'm happy to second the motion.
Okay. All right. So the motion is to approve the application, including forestry condition number 2, the condition in the planning report dated July 13th, the removing variance number 2 and amending variance number 4 to read 1.13 for square meters of 230.36 square meters, moved by Mr. Reed, seconded by Mr. Nipfel. All in favor? Okay, the application has been approved as amended. The next item is item number 27. 21 Cowan Avenue. We have before us a copy of the plan of survey, site plan, floor plans, and elevations, presentation material from Sava Mijokovic, the agent, and we have an 11 signature petition in support signed by residents on Cowan Avenue and one resident on 18 Trenton Terrace. I don't show any opposition speakers, and I don't have any conditions. Is the agent on the line?
Good afternoon, Madam Chair, members of the committee. I'm Sava Mijokovic, the owner's agent.
Hi. I don't think we need a presentation. Panel members, do you have any questions of the agent?
No.
No? Okay, Mr. Miokovich, we have read all the material, we're ready to go into committee. Is there anything you want to add that's not part of the submissions?
Nope. I'm happy to pass it on to you guys.
Alrighty, let's take it into committee then, panel members. Mr. Nipfel?
Madam Chair, I think this is a sensitive intervention. There is it's minor revisions. It enjoys the support of the neighbors on both sides. The third floor addition is tucked in behind an existing roof form that clearly mitigates any imposition of the third floor on the street. All in all, I think it's an excellent submission, and I'd like to move approval without any conditions.
Okay, do I have a seconder? Mr. Reed keeps beating you to it, Mr. Clay. What can I say?
Peter's a Jeopardy player.
All right, motion to approve, moved by Mr. Nipfel, seconded by Mr. Reed. All in favor? Okay, the application has been approved. Item number 20.
Great, thanks for the feedback.
Okay, thank you. Item number 28, 71 Poplar Plains Crescent. We have before us a copy of the plan of survey, site plan, floor plans, and elevations, presentation materials, and planning rationale from Maria Denegri, the agent. We have forestry asking for conditions 1 and 2, support letters from number 84, 77, 75, 64, and 76 Poplar Plains Crescent. Opposition from number 74, 73, which is adjacent, 79, 70, 82, and 81. And I have opposition speakers, so can I please have the agent on the line, assuming you're there?
Yes, I'm here.
All right, so we do have opposition speakers. I'm assuming that you're speaking on behalf of the owners, because I do have them listed here. Is that correct?
Yes, I will
Okay.
be making a presentation on behalf of the.
Okay, you're gonna have to speak up because I can't hear you at all.
Okay, can you hear me now?
Barely. Hang on, we're gonna try adjusting the volume. Can you say something again?
Okay.
Hang on.
Can you hear me?
Okay, yeah.
Let me try.
No, we're good. We're good now. Yeah, my colleagues here have made some adjustments. So we're going to give you 5 minutes for a presentation because I do have 3 speakers listed, and we're going to start the clock now. So go ahead.
Okay, my name is Maria Denegri. I am from Denegri Westside Studio, and I am representing my clients, owners of 71 Poplar Crescent. We are requesting two variances today. The first variance listed is for an FSI. The maximum permitted floor space index of the detached dwelling is 0.35. This would be an area of square footage of, an area of 107.48 square meters. The altered dwelling that we have proposed has a floor space index of 0.75 for a total of 230 square meters. My clients presently live in one of the smallest houses on Poplar Plain Crescent. The existing house with an FSI of 0.42 currently exceeds the allowable 0.35. The proposed request of an FSI of 0.75 represents a gross floor area of 230 square meters. This is a modest sized home consistent with the size of homes in the neighborhood and appropriately sized to accommodate the daily needs of a family of 4. Numerous design considerations were taken by my clients in the early planning stages to control the square footage. My client's request for an FSI of 0.75 will not set a precedent as suggested by several of the letters of opposition. A recent study of C of A approvals show that numerous neighboring houses currently have an FSI that ranges from 0.72 to 1.05. In particular, I'd like to note that the adjacent neighbor, 73 Poplar Plains, has an approved FSI of 0.76 with a gross floor area of 254 square meters. 76 Poplar Plains is 0.72 with a gross floor area of 295 square meters. 84 Poplar Plains has an improved FSI of 0.97, a gross floor area of 412 square meters. As you can see, there are numerous houses that are far larger than what we are proposing, which again is only 230 square meters, which seems to be very reasonable for a family of four. The next variance that we are requesting is a side yard setback of on the east side. Now, this is a setback requirement, is a variance for an existing condition. The required variance is 1.2. We are requesting a side yard setback of 0.18. The renovation of the existing house proposes to use the existing wall along the east side lot line. This variance is for an existing condition as we are proposing to build on the existing wall. The new rear addition is set back to conform with the 1.2 setback. I would also like to note at this point that the east side yard, the east side yard is actually unique in that it's not adjacent to another side yard, but rather adjacent, it borders a series of rear yards of the houses on Rafinelli Avenue. So that means that our proposed addition on top of an existing wall would actually be as far back from other houses on Rafinelli in the neighborhood of 7.5 to 11 meters. Our application, I am aware, has received 6 letters of support. One was actually submitted late. But I'm also aware that we have 7 letters of opposition. These letters appear to be somewhat coordinated because they all cite similar issues of concern. So I do want to take a few minutes to address some of these, in particular those raised by the immediate neighbor at 73 Poplar Plains. Okay, so the first concern is citing the size of footprint and impact to the windows and access to light. So the proposed project extends the footprint of the existing house by adding area to the west and to the south. The allowable building length has not been exceeded. Required setback along the west is maintained, and the building height is also respected. The two houses, that is my client's and 73, will be separated by 1.6 meters of distance. That distance is generous enough to allow sunlight to filter through. All but one of the windows referenced in the neighbor's letter is on the original side wall. It's generally understood that these windows predate zoning bylaws and building codes, and so typically are grandfathered in.
I'm sorry to cut you off, but you are over 5 minutes, and you will be back to rebut concerns from the neighbors. So can you wrap up, please?
Sure, I can wrap up. I mean, another major concern that was listed was injury to the main tree. It is the tree that sits in front of the property is actually a city tree. It will not be injured nor removed. We've actually designed the driveway in such a way to avoid the tree protection zone, and we've hired an arborist already to identify what tree protection measures are necessary. I think that the important thing that I'd like to conclude with is that the variants that we're requesting are actually existing. It is a modest, in my opinion, they are minor. No new variances have been requested with this proposed renovation, and I do believe that we meet the general intent of both the zoning bylaw and the official plan.
Okay, thank you very much. So as I said, we'll have you back after we hear from the opposition. Okay, thanks.
Sure.
Do I have Joseph on the line?
Yes.
Hi, can you just state your name and address for the record, please?
Joseph Zankwitz, 82 Poplar Plains Crescent.
Okay, we'll start the clock now. You have 5 minutes.
My main concern is the massing of the development on the front of the street and the way that the garage is embedded in the building. I'm hoping that the applicant can articulate the front of the house so that it's less massive in terms of what's happening on the street. That's my main concern.
Okay. Panel members, do you have any questions of this speaker? Okay. All right. I hope I pronounced your name right, Mr. Zankovitz. I hope we'll have the applicant back after we hear from all the speakers, and then she can address your issue then. Okay, do I have Sonia or Stephen Freed on the line?
Hi. Can
Hi.
you hear me?
Oh, yep, loud and clear. So
Perfect.
we'll start the clock now. Go ahead. You have 5 minutes. You're at 73 Poplar
So-
Plains. Is that right?
That's right.
Okay.
We live at 73. Hello to Madam Chair and the committee members, and thank you for the opportunity to speak. You know, we all take pride in our homes, and we actually welcome that there are new developments. We've developed our home, but we were very, very careful not to upset our neighbors. We spoke to them, we negotiated with them when we did an extension, and we got their approval, and everything went through smoothly. And I know the committee knows that neighborhoods are more than just statistics, because really you've been talking about statistics, but there hasn't been any discussion about the impact of violating some of those statistics. I would like to thank the architect for belatedly acknowledging that they would pave the softscape right-of-way to our door, which ultimately would have been blocked, and that they're going to preserve the large tree. But I'd like to comment that the neighbors have been invisible in all of this. They never came and contacted us, but they contacted people all around the neighborhood asking for approval. We reached out to the architect, and until about 6:30 last night, we never got a response. And the response we got did not answer the question we asked. So really what this is about is we have 11 windows, of which 10 are going to be completely blocked. We accept that that's not a variance, and we're not going to discuss it further. But the 11th window, which goes into our dining area, our kitchen, and where we eat, we have right now natural light. We can see the sky, we see the sun in the 4 seasons, and we can see the streetscape. They've been unable to tell us in clear terms where the house will end. We've had 2 people come and do measurements. One thought the house was going right to the window edge, and the other thought that the house was going into the middle of the window. And this large house will be staring at us when we eat, and will also be partially blocking our view that we've actually had unimpeded, not for ourselves directly, but in the neighborhood since 1929. And we accept that there's progress and things change. So, and their use of statistics is self-serving, and it's almost an aggressive use of stats, telling us that they were building a large house and that there are other large houses on the street. It really is not stating very much. They should be looking at what the average size of the houses are and the impact of what they're doing. So we have a very simple request, and it's predicated on a combination of things. We were quite happy to negotiate this before the Committee of Adjustments, and we're actually frankly baffled that the party in question made no attempt to deal with us. We still don't know precisely where the end of the house is going to go. And the second thing, we just want the house to be put back a few feet. We suggested 10, but we're quite happy to negotiate, and it will still be a big house if the house goes back a few feet, but our quality of life and the enjoyment whoever lives in our homes for the next 100 years will be greatly enhanced. So thank you for listening, and I'm happy to discuss things further.
Okay, thank you, Mr. Freed. Panel members, do you have a question of the speaker? Okay, seeing none. Ms. Rigo, are you there?
Oh.
Hi, can you speak up a bit? I can't hear you very well.
Okay, can you hear me now?
Yeah, a little bit better. Can you just give us your name and address for the record, please?
Okay, is this regarding 48 Silverthorne?
No.
Okay, so I don't know
So,
what's going on here. I've been waiting here a long time.
okay, this is 71 Poplar Plains. I don't even recall that address on the agenda today, is it?
Yeah, I sent an email.
Okay, just a second. The staff
They told me the meeting was today.
Okay, well, hold on. The
So
staff.
I'm feeling it's tomorrow now.
Okay, the
Yeah.
staff's going to answer your question right now.
I'm just looking up the application now, and it looks like this is going to be heard tomorrow, scheduled for 10 a.m.
I just wasted 2 hours of my time.
Oh,
Okay.
I'm sorry.
All right. Yeah. Thank you.
All right, thank you. Okay, all right, now my whole train of thought is gone here. No, hold on. Back to Ms. Denegri, the agent. Are you there?
Yes, I'm here.
All
Can
right.
you hear me okay?
Yeah, we've got you now. Sorry, we got a little,
Okay.
you know,
No, that's okay.
sort of
Sidetracked.
sidetracked. Thank you, yeah. So if you can just speak to the issues that were raised by the neighbors, that would be appreciated.
Yes, I guess just briefly to comment on the massing of the house and the kind of integrated garage. We have done a kind of careful study of the neighborhood. There are numerous garages that have been integrated into the fronts of homes. And one of the main drivers for that was to kind of increase the softscape and greenscape in the rear yard, right? The clients, as part of the renovation, have removed the existing garage that presently sits at the rear of the property and is accessed from a driveway that fronts the neighbor at 73 Poplar Plains. As far as the kind of character of the home, I'm hopeful that in the renders and supplementary material that was part of the application, that you see that the design is in keeping with the neighborhood, and in terms of both scale, character, materiality, and the angles and geometry of the sort of roof proposed. Now, to address the concerns of 73 Poplar Plains, with regards to the windows, I'm not exactly clear which window is the family room or the kitchen window. I'm assuming it's the one at the rear of the property that is part of his own extension, because all the other windows are presently on the existing brick facade, which currently front the existing house. Now, that rear addition, that faces east, it's got a variance of 0.47, and that window, my assumption, was allowed in a wall that close to the property line because they perhaps bricked in some of the existing windows. Typically, in new construction, you would not be allowed to have a window any closer to a property line than 1.2 meters. The window in question is currently partially blocked by the existing garage. By removing and that garage is actually only 0.1 meters away from the property line. By removing that garage and actually putting a new home 1.2 meters away from the property, I think that we're kind of opening up that area. I did address their questions in an email end of day. I apologize for missing their email. They contacted me to a general mailbox, which I only check in frequently. are in compliance with the building length, and we are in compliance with a setback. I mean, I understand that they got used to having a driveway next to them, but the existing distance between the houses is 2.6 meters. We're now going to have a distance between the homes of 1.6 meters, which for, you know, for side yard right of ways, it's actually quite generous. The agreement to kind of maintain that space, paved, semi-paved, is something that my clients are very happy to do, but they would also like the opportunity to put some planting along that 1.2 meter stretch. I don't know if my client wants to address any other issues that were raised in terms of contacting neighbors. I know that they did do a sort of general round. Now, who was contacted and who was not contacted, I cannot speak to.
Okay. Okay, I can take Nadia, but for about a minute, because we're almost at 5 minutes here. So if she's there, if she wants to speak. Nadia, are you there? If you just want to speak to having, like, who was contacted and what kind of circulation?
Yes. Yes, could you hear me?
Yeah, go ahead. And you're the owner of 71 Poplar Plains Crescent, correct?
Yes, I'm one of the owners. We own it with my husband, but I will speak.
Okay, so I'll give you about a minute, but only to address who you talked to and what you did, to let people know about.
Yes.
Okay, go ahead.
We have spoken to many neighbors in the neighborhood as evidenced by the letters of support. Several of the people who submitted letters of their opposition we have reached out to and had a dialogue. Now, I probably was naive by not reaching out to number 73 earlier on, but I have reviewed the Committee of Adjustment decision with regard to their property, which received larger FSI variance and this bigger exemption on the position of the extension.
That's not what the chair was asking you.
I understand, but it didn't occur to me that they would object to something that is less than what they themselves have asked
The
for.
chair just
So I
wants to
did
know
not
who you
ask them.
consulted with.
So I guess I'm just trying to establish.
I'm
who-
sorry.
So, yeah,
Sorry.
I don't need justification because we've been listening to
Okay.
the justification. So basically, I guess you felt it not necessary because they had a bigger exemption, so you did not reach out to them. Is that correct?
Yes, but I've contacted out of those who, for example, letters of objections. Would you like me to name the
No,
properties?
I read them all at the beginning. Thank you. Okay, so understood. I guess if you ever encounter this kind of situation again, it's just best to reach out in particular to your adjacent neighbors regardless. But I think with that, we're ready to take this into committee for a decision. Okay, panel members?
I'm happy to start. I think that we only really have two variances in front of us, and in my view, they're relatively minor. I looked at the neighborhood and the street, and this is a neighborhood characterized by large homes, large lots. The existing build on this site is comparatively smaller than just about everyone in that neighborhood. It's not surprising that someone would come along and put something a little bit larger. In my view, the facade, the massing, there's no height variance, there's no depth variance. I think this house and this proposed build fits in reasonably well with the neighborhood. It's not excessive. I don't really think that it impacts the neighbors in the neighborhood negatively. And for those reasons, I'm prepared to support this application.
Okay. Anybody else, or otherwise, Larry, you want to just move the motion? I see.
Sure, I'll just move a motion, again, subject to my colleagues agreeing. I'm happy to move a motion to approve this application, I think, subject to forestry condition number 2.
And 1. 1 and 2, I think.
Oh, is it 1 and 2? Pardon me, I missed number 1.
No worries. Do I have a seconder? Mr. Reed? Okay, so the motion to approve by Mr. Clay, seconded by Mr. Reed, including forestry 1 and 2. All in favor? Your application has been approved, and thank you everyone for your input. Panel members, we have 3 items in this time slot. Are you okay to finish them and then take a break? Yeah? Okay. So the next item is item number 29, 102 Edmond Avenue. We have before us a copy of the plan of survey, site plan, floor plans, and elevations. No other correspondence, no conditions, and we have 2 variances before us. I don't think we need a presentation on this one. Is the agent on the line? Mr. Sania, or? No.
Hi.
Hi, okay, we don't need a presentation, sir. Panel members, do you have any questions?
No.
Okay, and is it Sayania? I'm not sure I'm pronouncing that right.
Yes, no, this is correct. Pejman Sainia,
Okay.
from Rigid Frame Structure Engineers and Architects.
Excellent. So we don't have any questions. We've read all the material. Is there anything you want to add? We're ready to go into committee to make a decision.
I don't want to add anything. To me, it's a very simple project.
Yeah, I think we feel the same way. That's why we don't need a presentation. So, all right, so we'll take it into committee for a decision then. Is Carl, were you speaking? If you
No,
were.
I was going to move a motion.
Yeah,
No.
even better. Go ahead.
Madam Chairman, I think this is very straightforward. It's single variance. The variance is not at all unreasonable. I don't see any negative impacts to approval of this. I'd like to move approval without condition.
Okay, and do I have a seconder? Mr. Reed? All right, motion to approve, moved by Mr. Nipfel, seconded by Mr. Reed. All in favor? Application's been unanimously approved. Thank you. Next item number 30, 78 Neelan Avenue. We have before us a copy of the plan of survey, site plan, floor plans, and elevations, covering letter from Mr. Lang, the agent. We have correspondence from planning. They have no concerns, no conditions. And we have support from number 76, which is adjacent. Can the agent please identify himself for the record?
Hello, it's David Lang, 2100 Bloor Street West.
Thank you. Panel members, I don't think we need a presentation. Do you have any questions for the agent? Seeing none? Okay, there don't appear to be any questions, Mr. Lang. We've read the material. Thank you for your covering letter. Is there anything you want to add that wasn't in your submissions?
No, that's fine. Just happy to answer any questions that the panel has.
I don't think they have any. I think, so we'll take it into committee then. Peter?
Yeah, I'm happy to go ahead and move a motion for approval. I think this is a sensitive addition with most of the massing happening up top and in the back, and is really indicative of what's happening in the neighborhood, particularly with its immediate neighbor at 76. Who it enjoys the support of as well. So I move a motion to approve this application with no conditions.
All right, Mr. Nipfel is your seconding, so motion to approve, moved by Mr. Reed, seconded by Mr. Nipfel. All in favor? Your application's been unanimously approved. Thank you. Item number 31, 193 Parkview Hill Crescent. We have before us a copy of the plan of survey, site plan, floor plans, and elevations, covering letter from Mr. Spagnolo, the agent, as well as previous decisions and a building permit affecting the subject property. We have support from number 197 Parkview Hill, as well as 210 and 44 White Pine Avenue. I don't have any speakers listed. Do I have the agent on the line?
Yes, hello.
Hi, can you just identify yourself for the record?
Hi, I'm Franco Spagnolo from Studio Spagnolo, the owner's authorized agent.
Okay, panel members, I don't think we need a presentation. It's 2 variances before us. Do you have any questions for the agent? Seeing
Just
none?
confirming, so, Chair, just to confirm,
Yep.
so you've had a building permit for this, for the pool, and you proceeded, or someone proceeded, and now there's a variance required, is that correct?
That's correct. The owner submitted for an application, then the pool contractor mentioned that he'll take care of the approval. Unfortunately, it wasn't passed, and now we're dealing with this condition to legalize the existing condition.
So it's just basically a technical amendment.
Correct, yes.
Mr. Nipfel?
The fencing and screening of the pool from the street, from White Pine is on the public right of way. Do you have the approval of the city for that fencing and screening?
Yes, that's an existing condition that's been there. It's typical for corner lots, and that was part of the original, I believe, the original house when it was built in 2018. I can confirm that with the owner, but yes, that's an existing condition that will be used as the enclosure.
And the enclosure has the approval of the city because it's on city property.
Correct, it is on the boulevard. Yes.
Okay.
Any other questions? Okay, seeing none. Mr. Spagnuolo, we're ready to go into committee. Anything else that is not in the submissions you want to add before we make a decision here?
No, I'm okay. If you guys have any questions, I'm here to answer.
No, I think, Mr. Nipfel, are you ready to move a motion, or you have another question?
Yep.
Okay.
No, ready for a motion.
Okay, go for it.
I'd like to move approval without condition. This is very straightforward. I don't see that there's any difficulty with the pool, and the property owner that might be the most affected is in support of the application. So I'd like to move approval without any conditions.
Okay, Mr. Clay, you're seconding, so motion to approve, moved by Mr. Nipfel, seconded by Mr. Clay. All in favor? Applications unanimously approved. Thank you, and let's take a break till 4:05, and then we'll come back and we'll be starting with item 32, which is 174 Sunnyside Avenue.
Did you mean 5:05?
Oh, 5. I'm looking at the clock, totally, I'm losing it. 4:35.
Okay, it's 4:26.
4:35 is what I meant, Carl. Thanks for pointing that out, though.
10 minutes.
Thank you. Thanks.
Okay. Panel members, we're ready to go? I don't know if, well, we can start with Peter. I'll just start by reading the things we have. Okay. The next item is item number 32, 174 Sunnyside Avenue. We have before us a copy of the plan of survey, site plan, floor plans, and elevations. We have correspondence in opposition from 147, 145 Glendale Avenue, as well as 176 Sunnyside, which is adjacent, and owners of another property on Sunnyside, but we don't have an address for that. I'm not showing any speakers listed. Okay, Peter, just in time. You just missed the blurb. We don't have any planning reports or anything in front of us, and I think you read the submissions, so you know the opposition. Okay, so can I have the agent please identify himself for the record? Mr. Chopra, are you there?
Raul, you've been unmuted. Mr. Chopra, we can't hear you. I'm going to try and give you a call on the number you registered with. Just a moment.
Okay, panel members, we're just going to give the agent a call. Can't get him on the WebEx here. Okay, we're gonna move on to, we're gonna hold this, and I'm gonna move to item number 33. You got him? Oh, he's here? All right, panel members, we're going to move to item 33. In the meantime, staff will try to get a hold of the agent for number 32. Okay, so, item number 33, 59 Crescent. We have before us a copy of the plan of survey, site plan, floor plans, and elevations, a covering letter from Randall O. Tulakowski, the applicant, as well as previous decisions affecting the subject property. We have an 18-signature petition signed by numbers 5, 6, 8, 14 Hemlock, 53, 54, 55, 56, 60, and 67 Crescent. And do I have the agent on the line?
Yes, you do, Madam Chair. My name's Randall Odlikowski.
All right. I don't think we need a presentation on this. We only have one variance before us. Panel members, do you have any questions for the agent, Mr. Nipfel?
Carl, you're muted.
Carl, I think you're muted.
Can't find the button to unmute. There, is that okay?
Yeah, you're good.
I think it's a very straightforward application. The only concern that I have is you have support from a number of properties, but absent from the support of the neighbors on either side. Have you had conversations with them? Are they opposed? Are they in support and they just haven't written a letter? Could you give me some background on that?
Yes, I will. I will try to be as brief as possible without going into much detail. I did not talk to either party on either side of me. The one at 57, unfortunately, I'm not on speaking terms with her. She had attempted to cut down the tree at the front on city property a couple of months ago, and I stopped her from doing so by calling the city. So,
okay.
For those reasons, I didn't talk.
That's 57. That's 57, right?
Yes.
Okay, and then
yes.
61?
The situation is sort of similar. They sued us to park in the right of way and lost in the court of law. at the beginning of May, and so we're not on speaking terms, unfortunately.
Okay, thank you very much.
Yep.
Any other questions, panel members? No? Okay, Mr. Otulakowski, we've read the materials. We have no further questions. We're ready to go into committees. Is there anything you want to add that's not already been submitted?
No, I'm fine. Thank you.
You're good? Okay. All right, panel members, we're in committee. Mr. Niffel.
Madam Chairman, I think this is very straightforward. There are other enclosed porches in the area. I don't think that what they're proposing to do is in any way out of keeping with the context in which this property finds itself. I'd like to move approval without condition.
Okay, do I have a seconder? Mr. Reed? Okay. Motion to approve, moved by Mr. Nipfel, seconded by Mr. Reed. All in favor? Your application's unanimously approved. Did you get anybody? I'll keep going on the list. Okay, moving on to item 34, 323 Oakwood Avenue. We have before us a copy of the plan of survey, site plan, floor plans, and elevations. We have 5 form letters in support from 120 Earlsdale, 337 Oakwood, as well as 321 and 325, both adjacent neighbors, and 34 Blandford Street. And I don't have any staff reports. Okay, do I have the agent on the line?
Yes, I'm here.
You're there. Okay.
Good afternoon, Madam Chairman, members of the committee.
All right.
My name is Alan Stone. I'm the architect for the project.
Okay, and you're speaking on behalf of the owner, correct?
That's correct.
Okay, panel members, this is pretty straightforward. I don't think we need a presentation. Do you have any questions for Mr. Stone? Mr. Nipfel?
Mr. Stone, again, have you had any conversations with the adjacent neighbors? It would appear to me that the north and the south edge of the second floor deck should have privacy screening added to it.
We've spoken to both neighbors. As a matter of fact, the owners did directly, and they don't have any problem with anything that we're doing.
Okay, so they didn't necessarily ask for a screening of any kind?
They did not necessarily ask for screening.
Okay, thank you.
Any other questions?
Just quickly, Chair,
Yep.
if I might, can I just confirm, so are you keeping any of the commercial?
No, it's all being converted to residential. In fact, it was being used as a residential completely anyway, perhaps illegally, I don't know. The reason that we're keeping it for the residential use is the owner is a musician and has some rather large musical instruments, big pianos, and this way he can practice and do his work in terms of being a musician without having to disturb the family. I mean, we just don't have enough room to take grand pianos upstairs.
Thank you.
Any other questions? Seeing none. Okay, Mr. Stone, we're ready to go into committee. We've read the materials. Is there anything you want to add that's not in the submissions that we should know?
No, Madam Chairman.
Alrighty. Panel members, we're in committee. Mr. Clay, did you want to start?
Yeah, sure. I think we're on a roll. These ones are, we're into a little period of fairly straightforward, and I think this similarly is a fairly straightforward one. See absolutely no impact on the street or on the neighborhood. I think this is totally supportable and very minor in nature, and I'm happy to bring forward a motion to approve with no conditions.
Okay, Mr. Nipfel, you're seconding. Okay, motion to approve.
Yes, I am.
All right, motion to approve, moved by Mr. Clay, seconded by Mr. Nipfel. All in favor? Your application has been unanimously approved. Thank you.
Mr. Chopra, are you there? You've been unmuted.
Yes, sorry, can you hear me?
Yes, thank you.
Okay, give me a second.
Apologies.
Okay, give me a sec.
Yeah.
Just give me a second here. We're going backwards now. I gotta find where you're at here, or on my sheets anyways. Okay, so panel members, we're going back to item number 32. So we have before us, once again, a copy of the plan of survey, site plan, floor plans, and elevations, and this is for 174 Sunnyside Avenue. Correspondence in opposition from 147, 145, 176, as well as unspecified owners on the street. Okay, can you just identify yourself for the record, sir?
Sure. Good afternoon, Madam Chair and committee members. I am Rahul Chopra. I'm the agent for the client, 174 Sunnyside. Apologies again, and thank you.
Yeah, that's okay. I'm glad we got you. Panel members, we don't have any speakers. Again, this is a pretty straightforward application. We have one variance before us. Do you have any questions for the agent? Mr. Nipfel?
Just quickly, if I beg your pardon.
Doesn't matter. You want
Go
to
ahead.
go ahead,
Go ahead,
Larry.
Larry.
Go ahead, Larry.
Well, we might have the same question perhaps. I just, I was reading the letters of opposition and they're pretty concerned about size and overlook of the third story balcony. But I noticed on your plans that you have sort of quasi-enclosed. Is that correct?
Sorry, it was muffled. It is a guard height, and then it does go up. So it is screened for both the owner's benefit and obviously the neighbor's benefit, if that answers your question.
I just wanted to make sure that, I mean, the concern was a lot about the third story balcony overlook, and I think I'm satisfied that you've done a job about making sure that it's screened well.
I appreciate that.
Okay, Mr. Nipfel.
My question was exactly the same, but I'm not convinced that the solution is addressing the concern. If you look at the north elevation, the proposal, and then if you look at the west elevation, in both cases, what you can see is that the person can clearly see out over the edge of the deck, both to the side and to the back. I'm reluctant to monkey around with that, the way in which you've articulated that extrusion. It's really quite handsome, but I don't think that's enough of a visual barrier, given the concern of the neighbors. Normally what we would ask for is a 1.5 meter opaque screen, and if that condition were attached, I don't want to put a hardship in your way, but would you be able to adjust that angled line so that you could accommodate it in some way? Because I would like you to stay true to the intention of this design, but at the same time, as Mr. Clay indicated, and I agree, the residents are concerned with overlook, and I don't think that the solution you have addresses the overlook yet.
I mean, that's a fair point. I do prefer to keep the solution. I mean, I understand what you're asking about the 1.5 meters. Now, it is very prevalent where I've put the scaled figure at the very front. But most of the time, sitting on the balcony or actually using the balcony, whether you're, in the only case that you're standing right at the edge, will you really be that exposed? I prefer to keep it as it is in terms of the height, because I do think it does address it at the 3'6" variation versus the just under 5 foot. And of course it escalates from there on an angle from that 3'6".
No, for sure. Just I won't be able to support it as it's before us. So I would like to include a condition that provides for better screening, but I don't want to introduce a condition that's going to negatively impact the appearance of the building. And I appreciate the way you've got it. It's really very handsome, but I'm responding to the neighbors who have indicated that the overlook from that balcony is a problem, and I agree with them. I think it is. I really think we need to have opaque screening that's higher than what you've got.
On that triangular piece there, right? On that front piece, Mr. Nipfel, you mean? Like that
If you look, well, it's angled. If
It's
you
like
look
a
at the
triangle, so that
It's
triangle,
like, yeah, if you look at the west elevation, it's at the height of a balustrade. And then from there, it angles back to meet with the pitched roof. It's a very elegant solution. I think it needs more height.
So, Mr. Chopra, I think what Mr. Nipfel's looking for is some opaque screening on the two forward-facing triangles, and if that's feasible. Is that kind of what?
Yeah, I believe that's something we can accommodate. The point I was making is I think at that very point we're at about 42 inches. So going up on that angle to get to the amount that's suggested at that 1.5 meter mark, it wouldn't be very far. So, I mean, I could adjust it so that it's at 1.5 meters at that height on that side of the balcony, for sure. But it'll be like kind of risen for just that little bit of piece. But yes, I mean, if that's what needs to happen to accommodate, and certainly I appreciate the neighbor's response, and I did read those objections. The intended use is mainly, for balcony purposes, for seating. So from that point of view, and for what it's going to be used for, I don't see that becoming an issue, but I can accommodate if that's the request of the committee members.
Okay, thank you.
Any other questions, panel members? Okay, seeing none, Mr. Chopra, we've read the materials. We have no further questions. We're ready to go into committees or anything that's not in the submissions that you feel we need to know?
No.
Okay, thank you very much. Okay, panel members, let's take it into committee for a decision.
Walter, I actually wasn't uncomfortable with the proposal as submitted. In part, I agree with the agent saying that for the most part, 90% of the time they're going to be sitting out there, going to be well hidden.
Hey, Larry,
So,
I don't
yeah,
know, you're
yeah.
coming across very muffled, like it's really difficult to understand you. Maybe try again.
Usually difficult to understand.
Well,
Is that better?
That's better. Yeah.
Okay, let me start again. I'm having my my earbuds. I wasn't terribly uncomfortable with the original submission. I thought Charles said is fairly elegant design, and 90% of the time when that's a bedroom, so people are going to be sitting rather than standing. So I wasn't uncomfortable with the original design, but I'll defer to the select view on this one, I think.
Madam Chairman, I think what the applicant has indicated, and I appreciate his flexibility, he's indicated that he could still preserve the elegance of the original design. He would just adjust the two side flanges of the balcony railing, and that's exactly what I thought needed to be done. Unless anyone was opposed to that, I'd like to recommend or bring forward a motion of approval subject to there being, and the way I'd have to say it is a 1.5 meter permanent screen on the north and the south edges of the third floor balcony. And as we've discussed, that's going to be accommodated by just reworking the side angles of that element that sticks out at the back of the building.
Okay. Is that a motion then with the condition, or?
That was a motion, sorry.
Okay.
I'll second that.
All right, so a motion is to approve the application with a condition that the screening on the north and south side edges be at 1.5 meters, adjusted by the applicant, moved by Mr. Nipfel, seconded by Mr. Reed. All in favor? Okay, the application's been approved with that condition. Did you need to adjust? Okay, we need a couple minutes. We've got to do the YouTube stream again. 2 minutes is all they need.